So another factor that can work in favor of a disproportionate division is if one spouse has a large separate property estate. And we'll talk more about separate property later in the presentation. But separate property is property that spouse gets to keep and doesn't have to share. So if you have a situation where one spouse has $1 million of separate property and there's only, let's say, $100,000 of community estate to divide up, that alone can be a pretty good reason for a judge to order a disproportionate division for the reasoning being, well, the spouse with $1 million separate property estate, they just don't need it as much because they're going to get, they have their own separate property. They already have a significant amount of cash. Whether you consider that fair or not, that's another debate, but that is another reason that judges sometimes do disproportionate divisions. Primary custody of children often plays into disproportionate divisions, and often these issues kind of work together, particularly the disparity in earning capacity and primary custody of children. If we just take a real common example, if you've got a husband is a highly paid executive and makes $200,000 a year, and wife is a stay-at-home mom at the time of divorce with 2 kids who are in elementary school, and those are facts that are very likely to lead to a disproportionate division because the judge will likely look at the situation and say, well, mom, frankly, needs the money more than dad does because dad makes a significant income and will well into the future, and wife is probably going to have to go join the workforce, and if she's been out of the workforce for a while, she might need some training and have to get some job skills. So those are all facts that lend themselves to a disproportionate division. The last one I have listed here is, like I said, the one that most commonly people think is the biggest variable, that is fault. Judges are most of the time, with the exception of family violence issues and that sort of thing, and sometimes extramarital affairs with really extreme facts, fault is usually less of an issue, less of a reason for doing a disproportionate division than these other issues are. So that brings us to key number 2 to understanding and getting a fair property division in Texas, that is understanding alimony and how alimony works. Let me go through a little bit of the history of alimony, just very briefly, so you understand the way judges view alimony. First of all, I use the term alimony, spousal support, and maintenance. They're all synonymous. Alimony, the tax code refers to it as alimony. The state family code refers to it as maintenance. Means the same thing. It's just a post-divorce stream of payments from one spouse to the other. So going through the history a little bit, from 1995 to the present, or rather until 1995, Texas had no alimony statute. The court literally had no authority to order one spouse to pay the other alimony. In 1995, a very limited alimony statute was enacted, and that statute stayed pretty much in its original form from 1995 all the way till 2011. In 2011, last fall, the statute was changed fairly dramatically, and there now is the possibility of, I would say, relatively significant alimony, at least significant as compared to the old statute. The old statute, the maximum that could be awarded for alimony, and first of all, you had to qualify for it, just like you still do now, but even if you qualify for it, the maximum that a judge could order was $2,500 a month for 3 years. In certain cases, that might seem like an extremely large amount of alimony, but when you consider the fact that if you're a professional athlete and you made 7 figures a year, and the maximum a judge could order that athlete pay in alimony was $2,500 a month for 3 years, it was pretty limited, and certainly pretty limited compared to what other states' alimony statutes allowed. Oops, let me go back one. Here we are. So we talked a little bit about alimony and the different names for it. It's a little bit confusing because it's called alimony, it's called spousal support, it's called maintenance. It all means the same thing. But to add to the confusion a little bit more, there's really 2 specific kinds of alimony. There is statutory alimony. That's primarily what we're going to talk about in this presentation. And that's what a court has the authority to order based on the maintenance statute in the Texas Family Code. That's statutory alimony. That actually is ordered, in terms of all the alimony that gets ordered, statutory alimony is in the minority. The much more common form of alimony is contractual alimony. Contractual alimony only occurs by settlement agreement, and the statutory maximums on duration and amount do not apply. So they don't specifically apply. A person can, by agreement, reach an agreement that alimony lasts for whatever period, however long they want it to, and for whatever amount they want to. They can. Your right to agree to that is not limited by statute. However, because the starting point is the statutory alimony maximums, then that is really going to dictate what the terms are in the contractual alimony. In other words, rarely do people agree to go beyond the maximums because they can't get hit any worse than the courthouse. So generally speaking, people don't agree to do worse than they could on their worst day at the courthouse. So we're going to talk primarily about statutory alimony. Contractual alimony is, even though it's not, the limitations don't apply, they kind of do because it gets factored into the negotiation analysis. So what's required to qualify for alimony? In a typical case, and I'm not going to talk in this case about cases involving either disability of a child of the marriage or of a spouse, or those cases involving family violence. Those are really separate issues. There's specific language in the alimony statute that treats those kinds of cases differently. But we're going to talk about a typical case and what's required in a typical case to qualify for alimony. So the very first issue is you have to have a 10-year marriage before you can qualify for alimony. You also need to be able to show that you are going to be, post-divorce, you're going to be unable to provide for your minimum reasonable needs. And lastly, you need to, it's really more of a defense than it is a requirement, but someone seeking alimony needs to be able to show that they have been diligent. This is particularly true while the divorce case is pending. They need to be able to show that they have been diligent in either looking for work or in seeking training, or at least having a plan as to what training they are going to seek post-divorce.